Okay, I'm in.
And other construction participants during all phases of projects, active claims, and something we're doing a lot these days based on the climate is actually representing community associations during active repair projects to fix defect issues as we come across them. And Tanmay, if you'd like to introduce yourself to the group.
Sure. Good morning, everybody. This is Tanmay Kadam, Director of Engineering at M2E, essentially lead the Discovery and Diagnostics service line here at M2E. What that is your, we help you guys through the 558 processes, through the turnover processes. Also, this service line, we perform our milestone inspections, your reserves, your recertification processes, and all forensic investigations pertaining to any of those. And if things don't go well, we'll probably help you through the litigation process as well.
Thank you, Jake. Thank you, Tanmay, for your introductions. So let's get started. When we talk about a construction defect, for those that are in attendance who've been involved in a construction defect lawsuit, or what's more commonly referred to as the 558 process or 558 lawsuit, let's dive right into that. Let's go to the next screen. What is the Chapter 558 Florida statute? Jake, could you walk us through and tell us what is meant by 558 lawsuit or 558 process? What is that?
Sure. It's a funny question in a way, Frank, because everyone just kind of refers to it as 558 as if everyone's supposed to know what it is. But what 558 actually is, it's a chapter in the Florida statutes that was created several years ago. It has not always been around, but now it has become a part of any construction litigation where there's an already completed project. And the idea of 558 is it requires the parties to essentially communicate amongst each other in an attempt to avoid litigation. So for a potential plaintiff, the idea is you have to place the potential defendants, maybe the developer, the general contractor, maybe the architect, or parties that you are aware of on notice that you have defects at your property, and you are providing them an opportunity to hopefully repair those issues and avoid litigation, or alternatively, to offer some sort of monetary payment to address those issues. Of course, not all cases settle immediately, but that is the purpose of the statute. We put some language in there, how the courts look at it. The judges like to be creative. It leads the parties to the waters of compromise. It does not let them drink. So that is the general idea. It's supposed to foster settlement to avoid lawsuits. And we find that sometimes it does, but sometimes it does not. And Frank maybe can speak to that a little bit more as to why that might be the case.
Yeah, and we're gonna dive deep into what are the different requirements of 558 timelines and those sort of things. What I have found is that although 558 is intended to avoid litigation, it's intended to avoid lawsuits, I've yet to find a case that actually fully resolves during 558. The one benefit that I have found is that some parts of your construction defect claims can be resolved during the 558 process. And the way I've found that it's been done is by using folks like Tanmay and his services. Tanmay, can you talk generally about what's the role of a company like yours during a 558 process or 558 investigation?
Sure, absolutely. So adding to what Jake and Frank were mentioning, the process, what is the process of 558, right? Given the background, the experience that us engineers have in how a building is usually built, what are the requirements? What are the code requirements? What are the standards? Essentially, after onboarding, what we do is reviewing all the pertinent documents to the property, which is the permit documents, submittals, RFIs, the contracts, right? What was the contractor supposed to do? How were they supposed to build this? Once we are familiar with the property, what we'll be doing is performing an on-field inspection on your property, understanding what we've studied from the drawings, making sure that what we see in the field is compliant with the code, with the industry standards, or with the permit set of documents, okay? Once we finish doing this first phase of physical inspection, investigation on the field, we essentially put all this in a report. Once that report's completed, done, we present it to the association and to the attorneys so that you have a flavor of what's really going on over here on your property, whether you have a lot of things wrong or you don't have a lot of things wrong. Once all the parties have gotten a chance to digest this information, this report essentially is then provided to the opposing side, wherein now they get a chance to review this process, review all these issues on the property. Then comes the walkthrough, which means is, hey, we've looked at the issues that you guys, the association, are claiming there are. Now let us actually put our eyes on the field and see if they are true or not. So this is the walkthrough, wherein us as engineers, we will walk with the opposing side, maybe the engineers, maybe the attorneys, or whoever there is, and show them all the defects that we found in the process so that they can look at it and whether agree or not agree to the process. Good.
Great. Thank you, Tanmay. So let me kind of digest some of that. When folks like M2E or other engineers provide us a report, what we call a 558 report, Jake and I are under certain requirements under 558 to take certain procedural steps after that. You have to get the report, you have to get a notice and send that out to the defendant and say, here's a report that's been obtained by an engineer that tells us, it diagnoses what is going on with this building that's supposed to be brand new, that's supposed to be in perfect condition, but in fact, here are all the issues that are occurring with this building. When we send that out, and Tanmay alluded to it, one of the things that are included in that notice and in that report is an opportunity for the other side to come out and do inspections and take a look at what M2E has identified in those reports, verify that the conditions are there. They can do their own testing if they'd like. And then they have after that, they have an opportunity to do one of three things. Number one, they can respond and say, you got me. Absolutely right. It's a defect. I'm going to go ahead and repair it. That's option number one. Option number two is, you got me. You're right. It's a defect. I'm not going to repair it, but here's the money that you need, association, to go ahead and repair it. And option number three, which is the one that we very, very often find, Jake and I in our cases, is you're absolutely out of your mind. There's nothing wrong with your building. It's all related to maintenance, and we're not going to do anything about it. And then we're off to the races. Jake, when we're going through this process, what happens if we don't follow the requirements set forth in 558? What happens if we just simply say, forget it, we're not going to file, send out a notice, we're just going to go ahead and file a lawsuit? What happens there?
Yeah, so and it shows on the next slide, the statute's actually pretty clear on this. Quite frankly, just delays everything. What usually happens in our practice is we might get a motion, for example, from a subcontractor we didn't know about who did not get the 558 notice, and they say, Judge, this thing has to stop. The lawsuit has to stop until we have the opportunity to review the engineer's report, to perform our inspections, and to provide our response to the extent we intend to provide. So what a judge might do, and what they should do typically in that situation, is stay the proceeding for that period of time until 558 is complied with. And that's typically what happens. What does not happen, and I believe it is a common misconception, it does not create some sort of defense that now the association's claims fail because they did not serve the 558. What it does do is it delays everything. And for most associations who want to get their repairs done, who want to get this dispute resolved as quickly as possible, you want to avoid any possible delays that you can avoid. And following the 558 steps to a T, according to the statute, in cooperation with your attorneys and engineers, is one way to avoid those delays.
Okay, and can we, if we go to the next slide, here we start talking about what are those procedures and specific timelines that we must follow when issuing a notice. Now, one of the things that we always come across is the timing of all of this, because the timing is important because we have, and we'll touch upon it a little bit later, we have to consider issues like statute of limitations, statute of repose, and there's been some changes to those to the statute of repose most recently, which we'll hit on in a few minutes. But in considering that the fact that there are limitation periods that have to be considered, and then looking at the Chapter 558 requirements, Jake, can you walk us through what kind of buildings do all buildings need to comply with the 558? Do they all have to issue a notice, or is there a certain requirement for each building and what they have to do?
So they all have to issue a notice. If it's a completed project, which pretty much all post-turnover associations are, you do have to issue a 558 notice, or else you risk those delays that I mentioned earlier. However, the time periods are different depending on the size of your condominium, for example. If you are more than 20 units, which a lot of these high rises are, the time periods nearly double, or they do double in some instances. For example, after a 558 notice is served for a condo with more than 20 parcels, the association has to wait at least 120 days to see through the 558 process before they can file a lawsuit. If they don't do that, then they risk that motion to stay that'll probably get filed by a defendant. For a smaller association, the time period's cut in half, which makes sense when you think about it, because inspecting a condo building with less than 20 parcels is not going to take anywhere near as long as inspecting one that is more than 20 parcels. And I'm sure Tanmay can talk about the differences in investigating extremely large high-rises versus maybe 2 to 5 story smaller buildings.
Yeah, no, sure. So essentially, when we get out on the field and we are looking at a high-rise that has 400 units in there, right? We don't want to just investigate or look at, let's say, 5 units or 10 units, because that's not a substantial amount of units for us to see what's wrong throughout the whole property. Ideally, we would love to look at 20% of the units and as much as common elements, common areas that are on the property, because then that gives us a better gauge of issues that are happening and or whether those issues are more widespread or not. Because essentially what you're looking at, if there's one issue happening, let's say, for example, you guys are having stucco issues on the building, and we only look at 5% of the property, that's not a substantial amount for us to justify whether this is a widespread issue or not. The larger the sample size, the better it is for us to give you an idea how big this issue is. Right?
Jake, let's get to the next slide. So, Tanmay, you were talking about these going and doing the inspections and looking over the property. When the engineer is out doing their initial inspection, you and I have talked about this before. The initial inspection is based just on visual observations. In other words, you're walking the property, you're getting into units, and you're seeing what can be observed without really disrupting any aspects of the building. You're not tearing out any tiles or cutting out any stucco at that point. You're just doing visual observations. Is that correct?
Correct. This is how I like to put it, right? Hey, let's say I had an incident and I feel I hurt my arm. So I go to my primary care and say, doc, maybe I have a fracture. I don't know what's going on. Can you please check it? The first thing the doctor's going to do is, hey, all right, let me have a look at it. Do you have a swelling? All right. Do you have a bruise? What's going on? Okay. Yeah, I do see a swelling. I do see a bruise, right? All right, let's send you to get your x-ray done, right? So that's essentially what we are doing. We're the doctors for your building. We'll essentially come and look at your property. We'll see what's going on, visually investigate it. Based on our experience, we can tell whether something is wrong with the property or not. And once we see that, then we'll further tell you, hey, look, we see something wrong. We don't know what the cause of that is. Let's investigate it and find out why certain things are happening. For example, typically we see a lot of issues with stucco. When we go out on the field, we see some delamination, we see some cracking happening in the stucco. Yes, there's something wrong, right? But the cause can be several. Is your stucco too thin? Are there not enough layers in the stucco? Is proper reinforcing not in there? Was it properly bonded, right? So several things can go wrong why certain defects are showing up. And for us to tell you guys, for us to justify what exactly is wrong, we have to investigate it. We have to do some kind of discovery testing.
So during this process, or during this part of the 558 investigation and process, this is where there's the most moving parts. And what I mean by that is, on the legal side, you have the attorneys preparing the notices, working on what documentation needs to be put together to disclose to the other side. They're also working with the engineers. The engineers are out to the property and they're identifying what areas they need to go and investigate and create their plans and results from that investigation. But there's also the property managers, and for those property managers that are on this call today, they're a vital part of this process, because the property managers need to contact the individual owners and get permission from those individual owners to come into their unit, and then coordinate with the board. And the board has the task of, for those owners that don't necessarily want anyone walking through their property, having that discussion with the owners and explaining the importance of having cooperation among the entire community to provide access to their units. Jake, can you talk about how do you juggle in your practice? How do you juggle all these moving parts? Because at the end of the day, it almost feels like in your position, you kind of have to be the master of ceremonies, kind of moving things around to make sure that it all works properly. Can you describe that process and what you've gone through?
It is an interesting balance, because on the one hand, especially when we represent condo associations in this process, we have 10 to 20, maybe more, different defendants and their attorneys reaching out to us and saying, M2E identified, damaged stucco outside of 30 unit balconies. We want to go into every single one, right? And that's the kind of thing that no property manager wants to hear. The last thing they want to do is call 30 unit owners. And by the way, 10 of them that are listed in that list are particularly difficult, and there's no way they're going to be cooperative. So how do we juggle those two balances, right? We don't want to be overly intrusive to the association, but we do have to provide reasonable access for inspections. And the way we typically do that is coordinating with the engineer specifically to figure out a list of units and an order for the actual inspection that the defendants are entitled to make it as efficient and orderly as possible, while providing a representative sample of the conditions that were observed. And Tanmay, maybe you can speak to how a 558 inspection might be planned on your end, and what you're looking to do when you're planning that inspection for the defendants.
Yeah, no, absolutely, and you're absolutely correct. I mean, communication is the key over here, right? You guys, Frank, Jake, you guys keep the communication open with us, and we also keep the communication open with the property managers, because the worst thing that you want, probably, let's say we have an investigation on a pool in the middle of the summer, you don't want 120 people in their bathing suits only to find out there is no water in the pool, right? Hey, yes, the engineers decide to investigate the pool today. Yeah, sorry about that. Please go back home. No, what we really have to do on our side is keep the communication line open between the property managers, between you guys, Jake, and also with the contractors, because we are engineers. We will be directing the contractors to open up the areas on the property. So we'll find a contractor. He's gonna come and say, hey, look, let's drop a swing stage over here. Let's open up these areas. So we have to coordinate the timing of the contractors when they're going to be doing certain investigations. Let the property manager know, hey, look, we plan to investigate X, Y, and Z stacks or units on this particular week on the month of May. So can you have this thing available for us? If not, let's move on to something else that is more feasible, that is more practical to do. So it's all about communicating and making sure that we have proper access to the property. in a more reasonable manner so we can finish our investigations.
So Tanmay, and actually this will go to both you and Jake. We've been talking now about selecting units and doing the investigation within the units. In our cases, in the cases we've handled, we always get this battle of, well, you went to that particular unit or you went to that particular location because you knew before you even got there that you were going to find the defect. You saw water coming out of that window, so of course you tested that window, and of course you found water. Why wouldn't you? But you can't say that it's happening throughout the entire building. Let's say we're dealing with a property that has 250, 300 units. Either one of you can take this question first. How do you deal with that argument that, hey, you went to that one particular location, and that's why you knew that it was going to leak there, and now you can't really, with the word that we use, extrapolate it to the rest of the building. I'll let either one of you go first.
Right, Jake, I can take it if you want.
Go ahead. Let's get your perspective first. Yeah.
Right. So I'll take a step back before we come back to this question, right? And I'll go to my favorite element, the stucco. So let's say we've done our initial investigation. We find some issues on the stucco. Initially, we ask people, hey, look, let us first identify what the general cause of this thing is. So we'll pick a sample size of stucco and open, let's say, 5 or 6 locations up. In all of those locations, we find, hey, look, this was consistently bad installation. The stucco was too thin, and a lot of things were happening around. Now, what we do is we go back to Frank and Jake and say, Jake, look, we found this issue and it's more consistent. I think this is where we need to get a statistical sample from a statistician and then investigate those areas, right? So this is where, Frank, what you were asking, hey, what do we do where we are being unbiased about our opinion, right? Because we have to take out, as engineers and also for you guys, to prove something that this is not a biased opinion on our side. It has to be completely unbiased. It has to be a randomly selected sample size, right? So what we do is we get a statistician on board. The statistician tells us what areas that particular person wants us to investigate. The person may come back and say, hey, these are the 30 areas I want you to go and open up. And out of those 30 areas, maybe not all of these areas show any kind of deficiency, but we still have to, because we have to be unbiased about this, open those areas up. Once we get that data, we present that data back to the statistician. Let's say out of those 30 areas, we find, again, 20 areas that are still showing some deficiency, but that were not visual to us. What the statistician does now is says, hey, with 95% confidence, we feel that 80% of the stucco is deficient as in thickness. With 95% confidence, we feel that 90% of your stucco does not have any bonding agent on it. With 95% confidence, we say that, hey, 95% of your stucco does not have any accessories done on it. And then they'll say, with 95% confidence, 99% of the areas of the stucco have either one or the other deficiency on it. So now this data can be presented to a judge or jury and say, hey, look, this is the statistician's report. This is completely unbiased because we did not just pick and chose the areas like what Frank was saying that was leaking or that we knew there were going to be issues. And this is the data that it shows. And now this is much a more scientific method of proving that there is a widespread issue on the property and hence your claim accordingly.
To that point, and from the legal side, what we're really concerned with when we're talking about random sampling is we want to make sure that your engineering company is able to diagnose all the problems that your building has. And if you're only focusing, as Tanmay said, on that one area that you know is leaking, on that one rust spot outside of your balcony, a few things are going to happen. The defendants are going to say, well, this isn't the whole building. This is just those few isolated areas. Why should I pay you to fix the whole building when all you've shown me is 1 or 2 locations with this problem? And by the way, those are the only 2 locations the engineers looked at. if we bring in a statistician, or if at the very least use some sort of random generator to pick other locations of the building, you avoid that cherry picking allegation that is quite frankly inevitable in most of these situations. And not to mention, you're going to get a better diagnostic of what's going on in your entire building. And I think that falls, under the cracks sometimes. And I think Frank could speak to this too. I think boards and management companies might be hyper-focused on the one unit or the one problem they know about. But if we're going to prove that this condition or any condition is systemic and throughout the property, really the only way to do this is to go through this, what sounds like a daunting process, and make sure that you do it right and get that representative sample showing what's going on in your entire building.
Thank you both for your responses. So let's move it along a little bit. Now we've done our investigation, we've gotten our reports, we've got our statistician. So we're bringing math into all this just to make things more complicated. And we get sampling plans, we go out and we do all this testing, and we get these reports, we send it out to the other side, and then we're done. And 2 weeks after we are, quote unquote, done with our investigation, the property manager calls and says, guys, I have these fire sprinklers that are just exploding, one floor after another. This is something new. This is something I hadn't seen before. What do we do? Jake, again, I'll pose this to both of you. Jake, are you limited to just one 558 notice? Is that fire sprinkler incident that occurred after we've already done our investigation and issued our reports out to the defendants? Does that act as a bar to any subsequent issues that may pop up in the building? How do you deal with something like that?
The short answer is no, but you still have to follow the process, right? You still want to notify everybody involved, presumably everyone you sent the original notice to, and potentially anyone new that you've learned about since. And something we didn't really talk about is part of this 558 process involves an exchange of documents. So after we send an initial 558 notice, we should be receiving contract documents from the original project, drawings and specifications, which allow the engineer to complete their investigation, but which also give the attorneys an idea of who gets what notices and who needs to be notified. So I give that background because if you find a fire sprinkler defect, for example, that you did not know exists, you better make sure to send a notice of that condition to that fire sprinkler subcontractor who you've hopefully identified by this point. And if you fail to do that and the new defect is not what they say is reasonably related to the original list of defects, that once again could be a basis to stay for the defendant. But I will say my first call after getting that call from the manager is going to be to the engineer because we're going to need the engineer to go out there and do their investigation about that supplemental issue. And Tanmay, how might you go about that if, for example, I were to call you and say, we learned about this new condition that you did not know about before?
Yeah, no, and again, the first thing that we have to identify as engineers is whether what you say is a life safety issue or not, right? If you're talking about fire sprinklers and things like that, that's life safety issue. So we right away have to identify that and do an initial investigation and figure out what's going on with that. So after our discovery, we can then present a supplemental report that we can say, hey, look, this is the issue. And if you really feel that this is more widespread and it's life safety, that has to be addressed right away.
Great. I think we touched a little bit on destructive testing earlier. I think we're kind of skipped around a little bit, which is fine. One of the questions that I always get from our clients is, when we do destructive testing, and the next slide is talking about best practices for related repairs, I think you can kind of, you can combine the two. The boards are always concerned when we're talking about destructive testing, where we tell them we're going to be opening up sections of the building and we're going to be putting things on the sliding glass doors, or that we're going to be opening up the front faces of the balcony edges and we're going to tear things up. They're like, well, wait a minute, you're going to leave my building that way? It's going to look terrible. Nobody's going to want to come visit. So we always have to deal with on the one hand, the destructive testing, whether, what do you do after the destructive testing is completed? And in the example that I gave earlier of the fire sprinklers that are bursting and leaking everywhere, are you required to just let the fire sprinklers leak? Can you repair them before you end up sending out these 558 notices? What do you do with these repairs? So Tammy, in terms of the destructive testing, once you're done tearing up these buildings, what do you do after? Do you just leave them that way and put a stay away letter in the front of the building, or what do you do?
No, so depending on different situations, like things like any life safety issues, fire sprinklers, right? Your railing issues and things like that. Those are life safety to us. So either you provide a supplemental or a secondary means of providing those safeties. For example, maybe in case of railings, you provide a secondary barrier system that prevents any mishap from happening. Fire sprinklers and things like that, those are life safety again. We have to start working on fixing those issues right away. Those are life safety issues. If there are issues that are not particularly life safety, but they are still concerning, then you essentially create a supplemental report, present it to the board, and you guys, Frank, Jake, and then the process, like what Jake was mentioning, let's start this claim for the 558 for those particular issues.
Yeah, and I just want to be clear, because again, I'm doing this for all of my board members that have always asked me this question. When we're doing destructive testing, once the destructive testing is completed, everything gets put back. Right. So you're not left with holes on the side of your building. You're not left with chunks of concrete removed just to see cables. Everything is put back. That's part of the destructive testing. So we do issue a notice to the other side and say, we're going to go do destructive testing. You have an opportunity to come, inspect, observe what's going on. And if you want to do your own destructive testing, defendants or construction parties, you're allowed to do it as well at the same time that we're doing our testing, so that you only do it once. But everything that's disturbed is always put back. When we're talking about the repairs, that's what Tanmay was sort of talking about, which is you have a repair, you have a leaking pipe in one of the floors, you have really when it deals with water or any life safety issues. Jake, can you talk about what steps do you need to take to make sure that the associations are not waiving any of their claims when they're trying to do repairs? They have, for example, let's say there's a balcony railing system that's not code compliant, or it's loose, and if somebody leans on it, they can fall. What do? Do you just let somebody fall? What's the process that you have to take?
So there's actually a slide, I think, a little later on talking about something called emergency conditions, right? You've all heard me and Frank talk about the amount of time, the amount of notice you have to provide. Typically, for non-emergency conditions, you need to provide notice to the defendants that you're going to repair it. So number one, they have the opportunity to observe the condition before it's repaired. And number two, so they can observe the repair and see what it is you're doing, because presumably at some point they're going to challenge it. That notice requirement, however, under the statute is not necessary for those types of emergency conditions that Frank was just talking about, and that Tanmay indicated earlier. For example, if there is a fire sprinkler that is going to create a code violation for your building that might lead to the fire department coming in and issuing a fine, or everyone's worst nightmare, shutting down the building, that is exactly the type of repair that you get to do right away. There's no notice requirement. You perform it. If your engineer is telling you this is a life safety issue, our advice to our clients is always take care of it, but in so doing, document it and let us, the attorneys, provide whatever notice we can as soon as we can. If it's the day of, it is what it is. Hopefully it's before, but sometimes that's not what happens. And everyone's primary concern, from the attorneys to the engineers, the board to the manager, is of course just the health, safety, and welfare of the residents. And that is the purpose behind that particular emergency repair exception.
I don't want to go too far. There was a question that just came up, and I think it's probably proper at this point. The question is this process for new construction or restoration as well? Jay, can you address that? If you're dealing with a restoration project versus a new project, do you still have to follow the requirements of 558? And then Tanmay, if you can touch on the difference between the two.
So it depends on the context, what I would say, right? Obviously, if we're talking about new buildings, there's no reason to provide notice because it's brand new. You're not in the process of suing someone or potentially suing someone. Typically, for the restoration projects that we're talking about, the purpose of that restoration is usually to repair defective conditions that have been identified in a prior 558 notice by your engineer. In that case, when you are doing those restoration repairs, let's say it's the stucco, you're going to fix the debonding that you put the defendants on notice of. That is exactly the kind of thing that you want to put them on notice of in advance. Because if you don't, there's an argument that you have spoliated evidence, a fancy term lawyers use for saying that you got rid of the evidence. Not to mention the 558 risks that you face, and they say we didn't know, so you have to put a halt on it. But typically, again, when we're talking about the 558 process, typically those repairs are always restoration. If the association, on the other hand, is maybe you're updating your lobby, you want to put in new tiles and make it look more modern, that is not going to typically be correcting a defect. I don't think you're ever going to hear Tanmay say, unless it's in the drawings and specifications, that lobby should look better. It should look fancier. It should look more modern. If there's no specific requirement in the project drawings for that particular look, that is going to be what we lawyers call a betterment. This is something the association could certainly do, but it's unrelated to the defect case. And because it's unrelated to the defect case, all those notice requirements that you have to worry about go out the window. And that can create a sticky situation for a manager or board who may not know, Jake, Frank, Tanmay, is this something that's a part of the 558? That's often what we hear. And Tanmay, maybe you can speak to that. How do you differentiate if something is a defect that's a part of the 558 notice, or just something that the association wants to do because they're entitled to do it?
Right. So I think the answer to that is very, very clear and simple, right? When we start doing those inspections, when we are trying to review things, there are three essential things that we try to gauge any issue by. Is it a violation or is it non-compliance with the Florida Building Code, which everybody has to comply with? That's the minimum standard. Is it a deviation from standards, industry standards that we're using? Or is it really a deviation from the permitted set of drawings? Because the permitted set of drawings have essentially to meet the Florida Building Code at a minimum. They can go beyond it. So those are the three things that we really look at. If there is any deviation from any of these three things, then those are the things that we put on a report, claim it, hey, this is a defect or a deficiency because it did not meet the following requirements.
So we've been talking about a lot of issues with the 558. We've talked and thrown out statements like notice and preservation of claims and spoliation and reasonable notice. So let me just provide this as almost like a public service announcement to our board members that may be attending or our property managers may be attending. We're about halfway through our presentation. I hope you get the sense of how involved these 558 claims and processes can be. The reason I say that is because they're not expeditious. You have to take your time with them to make sure that you've done and taken every step necessary to preserve your claim, to preserve evidence that Tanmay and engineers will need to use to testify upon, and to make sure that when you've gone through this process, that on the other end of it, you've set up your association in a way that you can either get the other side to go ahead and pay for the repairs or do the repairs themselves, or be able to go to court with a properly documented claim to present to a jury, present to a judge and say, here's our claim and here's how we followed every step of the 558 process. Jake, when we talk about spoliation of evidence, and I think you hit on it a little bit earlier, can you explain that a little bit and maybe give us an example of something you've dealt with in one of your cases?
Sure. So let's say, for example, that one of the parties that you are sending your 558 notice to, that you may be suing one day in court, let's say they constructed a pool, right? And you're saying that that pool was defectively constructed. And then the manager or the board or whoever wants to get that pool up and running again. Of course, unit owners are frustrated. They want to use their pool that they pay assessments for. It makes sense. Sometimes what we see is we might see a overeager board trying to make their members happy, for example, which is understandable. Go through that repair. Maybe there's a heater that's broken. Maybe it could be very minor, so it might seem like a maintenance issue to that manager or board. And then later on in the lawsuit, after it's filed, the defendant finds out, wait a second, you fixed this and you didn't tell me about it? How do we even know this condition was there if we didn't get the chance to see it? You can't prove to me in court that you had to incur this cost of fixing this particular issue. And a heater on a pool might be a very small thing, but we see that for larger projects as well. And that's why the lawyers, representing you in the background are very careful, or should be very careful, about making sure those advance notices go out. Because you do not want a defendant to tell a judge or a jury, how do we even know this condition existed? It's already fixed.
Thank you, Jake. And so Tanmay, now you're hired by an association and they have a pool on an elevated deck. The expansion joints around the pool are leaking. The pool is not holding its water. There's concrete spalling everywhere. This is a multi-million-dollar project that needs to be repaired. And you've been hired to go ahead and oversee, design, and get these repairs completed. One of the things that was in the prior slide was the requirement or the ability to get a bond. Would you recommend on a project like the one that I just described, would you recommend to that association to get a bond for a project of that size? And if so, why?
Yeah, no, absolutely. I mean, for issues like this is a huge, large scale project, right? Potentially millions of dollars for replacing of the swimming pool, all the leaks happening, because then you most likely have concrete restoration happening, replacing your waterproofing, et cetera, et cetera. Things like that, you definitely want to get a bond which does protect you from either non-payment of the contractor to the subcontractor. So potentially not having liens on your property, you don't want that. And also performance. Let's say, for example, halfway through the project, the contractor says, hey, I don't want to deal with this anymore, and disappears, then you're stuck with a pool that is halfway complete, and for you guys to go nowhere. So that's where you want these two kinds of bonds, the payment bonds and the performance bonds, to cover yourself, just so that you're not stuck with a lien, or you're not stuck with half completed projects.
Great. We've over the years, I've had cases where projects where, not before they hired me, I'll just give that disclaimer first. I've had associations that have undergone substantial projects, and when I asked the question, well, did you purchase a bond or did you require a bond to be purchased? They're like, what's a bond? And actually, Jake, if we can go back one slide, they asked me what is a bond, and there's different types of bonds. And on the screen here, we have a payment bond and a performance bond. Jake, can you just quickly go through the difference between the two, and should they have both on these particular projects?
So the short answer, I would say, is it depends on the size of the project. But if you're talking about a major renovation of a garage, of a tower, something where you're bringing in a contractor who has subcontractors, who might have suppliers. On those kind of large projects, at some point, what is probably going to happen is someone is not going to get paid on time, and they're going to want to record a lien. And I can tell you that there is nothing more frustrating to most property managers and boards than getting that email from one of the residents. I can't sell my unit. I can't get my refinancing because there's a lien from the project that you were all doing at the garage. Deal with it, right? So what a payment bond actually does is, with respect to everybody below the general contractor, it prevents them from recording those liens. Instead, if they're owed money, they can look to the payment bond. So it's very important for those larger projects where those payment issues are likely to come up. And again, your engineer or owner's representative can certainly give you guidance on what types of projects that might be. But this is one way to avoid that issue altogether. Because if there's a lien recorded, when there's an active payment bond recorded in the public records, it effectively shouldn't even exist. And as to a performance bond, I know you're not supposed to liken a bond to insurance because it's a different thing. Insurance has two parties, a bond has three. There's something called the surety, which insures the project, if you will. You have the contractor and the owner. The purpose of a performance bond is that if there's any incomplete construction, maybe the contractor didn't finish, item 10 of 10 on their list, the performance bond, if all the steps are followed, will ensure that the surety will either complete that work at no more cost to the association, or make sure that the contractor does it. So these payment bonds and performance bonds, I like to think of them as additional protection for the association to anticipate future problems that are likely to or may arise on larger projects.
Thank you, Jake. I want to take a minute here. There's a question that I just read that was posed by one of our participants, which I think is a great question. I don't want to go further in the presentation without looking at this one. The question is the turnover board that has to deal with the developer, and the developer tells the turnover board, "We want this building to be completed as much as you do. We don't want to pay. We don't want you paying for the repairs. We'll help you get the contractor to fix the issues. It's our reputation that's on the line." That's one of the comments. The other comment that the developer, I'm sure all of us have come through, is let's not waste money or on lawyers. My experience is that lots of wasted money and time is spent unnecessarily. We can save and put into the building and the unit owner's pockets. So let's not waste time with attorneys and engineers. Let's just go ahead and we'll get the contractor that did the original project to go ahead and fix the building. I'm going to talk about this for just a second, then I'll turn it to you guys. And the reason I want to talk about this is because I'm actually dealing with right now two of my projects there where I'm dealing with that same issue, where the board that took over after the developer was sort of told this, that these things, you don't have to worry about this, we're going to take care of the building. And after 3.5, 4 years of negotiating with them, and by the way, the statute of limitations to file claims, ticking, there was no repairs being done. The reality is the developers hire a contractor, the contractors hire subcontractors, and the developer generally hires a design team, and all of them are required to purchase insurance for this very purpose. The idea that the contractor is going to come back and just do all these repairs and stop working on new projects in which they're going to be paid millions upon millions of dollars is just not a realistic, and in my experience, is not something that contractors are willing to do. They rather turn the issue to their insurance carrier and let those engineers and those folks deal with whether or not there are defects. And instead of saying, okay, let me take my whole crew off of a multi-million-dollar project to come back to this project that I've already finished and do it at no additional pay. And the reality is that they've already done it wrong the first time. Why would you want them to come back and do it again? Is always the conversation that I have. But I'll turn it to both Jake and Tanmay, and let me know what your thoughts are on that question.
Yeah, I mean, from my perspective, I can speak to what I've seen, right? And typically, to Frank's point, if there is insurance on these major projects, which there usually is, sometimes there's not, believe it or not, there's typically someone who is going to step in and defend a potential lawsuit at no cost to the developer and the construction team. And often, there's insurance to pay for any potential claims in the lawsuit. So for some developers, they might be in a situation where they're really not facing any out-of-pocket expenses or liability if it's all going to be covered, by insurance. So in that situation, there might not be a lot of financial incentive for them to do it. But I will say, it's possible. We certainly have many boards who have relationships, personal relationships with developers of their buildings who might live there, might be their neighbors. And we've had other buildings where principals of the general contractor lived in the building. There's all kinds of situations that might arise where there might be extra effort on their part. But associations should be aware, should be very aware of the reality, and that is that in the end, it will ultimately be a business decision for all of these entities.
But and like what you touched base on, Frank, the goal of the developer and the contractor is to get out of the property as soon as possible. They want to start working on other projects that are already lined up. There's no incentive for them to stick around a whole lot longer. When they see an issue, they are going to look to fix that issue, but not investigate why that issue happened, right? You don't want on your building for them to just go around and fix one stucco issue because apparently there's a crack on there, but not knowing why that happened. That may have happened because the whole installation on your building is completely wrong. But what are they going to do? Most likely, they are only going to fix what is visible to them. And that is an absolutely wrong approach. That's an absolutely wrong way to do it, because 2 years down the line, guess what? The rest of the stuff is falling apart. And guess what? They're out of their property. And you're stuck with an element that's deteriorating progressively now. So you definitely want to make sure that you have attorneys on your side who can guide you through this process. It's not about wasting money. The amount what you start looking at is significantly so much smaller as compared to what you would be left holding when you have to repair your building all by yourself. Okay, you're talking magnitudes.
Yes.
So don't forget. Yeah, but the fees is yay amount, peanuts, as compared to when you really have to take those projects on. So don't skip on that. Make sure you have proper representation. Make sure you have people who look out for you and not just that want to just get things fixed and get out of the way, right?
That's a great point, Tanmay. And it actually leads to one of the other questions was asked, well, how long does all this take from the time that the property is turned over to the time that you get a resolution, whatever that resolution looks like, whether it be a trial or a settlement, or just whatever resolution can be described at in these cases. I'll take that initial shot at that, responding to that, is it usually takes a couple of years, but I caution that now, and I want to make sure that we touch on this before we end, so I'm going to ask you to keep your responses brief. It depends, because the new changes to the law in terms of the statute of repose impacts how much time the association will have to file their lawsuit, because that's really the critical point when you file a lawsuit after turnover. I would say that generally, most of the cases that Jake and I handle, we file them what's called a complex business division. So from the time that we file a lawsuit on these construction defect cases, there's a requirement that they from the time of filing to the trial date, which is the end date, it's between 18 to 20 months, maybe 22 months at the most, is sort of the time period that you have for the litigation. But what Tanmay and M2E do before could take several months before you ever file a lawsuit, because they need to investigate, find out if you even have a legal basis to file a lawsuit. If you guys want to touch on that as well. How much time it takes.
And just as a little interesting side note, Frankie mentioned that the law has changed. And particularly what he's talking about is that the outermost period of time condo associations used to have to file a lawsuit was 10 years from the later of the certificate of occupancy, the abandonment of the project, or the actual use of the project once the building is up and running. So the new law changed it to 7 years, and it also included TCOs, temporary certificates of occupancy, which could be issued even a year or more before the final CO. So what you have is a lot less time to file your claim. And if you're at an association that took a long time to turn over, you might run into some trouble. And I give you that little preface because there might be situations where you might even need to file your lawsuit before you have the complete investigation done. And that's a whole nother situation that you'd have to coordinate with your engineers. But if they don't have time and you're running up on that deadline, that's something that your lawyers have to look into very, very carefully based on the documents that should have been given to you by the developer at turnover. And Tanmay might be able to speak, to how an expedited review like that might work under the circumstances.
Yeah, no, absolutely. So, sweet and simple answer to this: the sooner you start, the better you have, the more time you have on your hands, right? Right from the get-go, typically, if you really want to expedite certain things and get on your property and start doing things, we can turn around these initial investigation reports. If we can expedite it about in a month and a half, 2 months after reviewing it. So at least you have that ball rolling. But otherwise, ideally, it may take up to 3 to 6 months to get to a phase where you have really submitted the report and now things are really rolling, where now the contractors have gotten, or the developers, engineers have gotten a chance to review that. They want to do a walkthrough. So again, it all depends on how friendly they are and how quickly they want things moving. So your best friend is time. Get things rolling as soon as you have an opportunity to.
Yeah, and just to touch base on what Jake was talking about, the new law to the or the change to the statutory repose law, it's a significant change for associations, for owners. It's significant because the time that you had after turnover has been significantly cut down, meaning that because the starting period now is the issuance of a temporary certificate of occupancy, that could be issued several years before the board that comes in after turnover actually takes control of the property. And so by the time that you come in to now evaluate whether you have claims, the statute of repose, not the statute of limitations, statute of limitations under 718 is still 4 years, but statute of repose trumps your statute of limitations. So if under your statute of repose, you only have 2 years left, even though you have under 718 and 9511, 4 years, you're down to 2 years. And again, what we talked about before, getting an engineer like M2E to come out and do an investigation of the property, while they are efficient and they will come out and do it as quickly as possible, for them to do a thorough job, it does take time. So it's a significant change. It's something that the new board's managers should be very well aware that once turnover takes place, you should be in contact with your attorney and saying, how much time do we have left to do this? Because it's changed. You don't have the luxury that we had before of additional time. Speaking of time, we're only about halfway through our presentation. Unfortunately, I think there has been a lot of good information that's been exchanged between these two, well-respected individual professionals. But we are out of time. We probably will try to do a second part to this series. We really appreciate everybody's participation. You have all of our contact information, and please feel free to reach out to any of us with any follow-up questions that you may have. On behalf of myself, I appreciate everybody participating today. I'll let these folks say their final remarks.
Thank you, everyone, for participating. I hope it was informative. Some of this, you hear these phrases, 558, destructive testing, and you might be new to a board or to a building. And I think it is, hopefully, was helpful to hear about some of this. Thank you.
Same thing. Thank you very much for the time. Hopefully, we were able to answer some of your questions, hopefully most of them. If not, please get in touch with us. All questions are welcomed. It's always better to ask questions than guessing. Have better professionals by your side who want to look out for you guys and make sure we guide you in proper direction.
Thank you, everyone. Have a good afternoon.
Thank you all.